Jeff, I think those are interesting stories, and it definitely goes, and that's a good tip to always have proof. Everybody's wanting to know what was the second time you got written up. So maybe that comes later.
Well, the second time I got written up when it was, I don't think I was ever written. Well, okay, there was a second time.
Well, we might have to save that for another presentation.
Sure.
Anyway, we'll go ahead and let you get back to it as we're continuing on, so we can make sure to get as much of the information in as possible. So take it away.
Actually, I do have to share the story because it's actually pretty entertaining. Okay, so my second time I was written up was I was assigned a case, a rather large case for a new revenue officer. It was a balance owed by an organization, and I worked with the folks, and I actually got them to give me a check for $2.9 million. And I was so excited that I went to my manager right away and I said, look, here's the check. I got the money. We're good to go. And she said, fantastic. I'm going to go ahead and review the case because obviously you did a great job. Well, apparently I didn't follow procedure, which would have required filing a lien, doing certain other steps before I got the money. I just jumped over everything and just went and got the money. And so because of that, I actually was written up a second time because I did not follow procedure. It was just about the results. So
yeah, so you got like $3 million. So
yeah,
you think they'd look the other way?
Well, unfortunately,
they can't because they're the IRS.
They don't judge on money; they judge on procedures.
Yep.
So okay, so let's stop boring people and move on. Okay, so keeping up with the hardship idea. So some of the questions that we would probably see are, how long does it last? Well, when it comes to hardship, it really kind of depends upon the scenario and situation. And you see three examples right there. One is if there is an increase in income. And we'll talk a little bit more about that in the upcoming slides. But the second one we have is an expected income increase. And what that means is if you basically are expecting some money to come in, let's say an inheritance, or you're waiting for a particular payout from something, and you're aware of it and you let the IRS know, they will set the hardship to match that time frame. So when that money comes available, they will kick it back out to the appropriate folks to collect. The other issue, which is probably the top issue when it comes to being kicked out of currently not collectible due to hardship, is not remaining compliant. The most important thing for the IRS is keeping people in compliance. They want you filing, they want you paying, they want you to keep your nose clean, basically, after you obtain a certain status like currently not collectible, or actually anything you do, whether it's installment agreements, offer and compromises. Any action is contingent upon remaining compliant in future actions. So let's talk a little bit about this increase in income. For further research, you can always look at the Internal Revenue Manual 5.16.1.6.1. And basically what this reads is the currently not collectible due to hardship will actually be rescinded, or your case will be kicked back out to collections if the total positive income comes in for the following year above the amount that's in the closing code. And I know that makes no sense, so let's talk a little bit about that. When you ask for currently not collectible due to hardship, the IRS will take a look at your client's overall annual expense structure. And they have a range. So it may be from 0 to 15,000, 16 to 30, 31 to 45. Now, obviously, you can tell that I'm making these numbers up, but there are ranges that the IRS uses to determine where your client falls. So, for example, if I have a client that I'm able to get into currently not collectible, and they have a current annual expense of, let's say, $42,000, they're going to fall into a certain range, and every year the IRS system will look at that and see if the following year's income is greater than that range they fall in. So in my example, this year they make 42 or 43,000. Let's say next year they make 60. Well, because that number has jumped and leaves the range that they were in during the currently not collectible, the system will automatically assume that now they have money to pay and they no longer qualify for hardship. And so the computers will kick that back out to collection to go get the money. So I hope that kind of makes sense. But just keep in mind that if your client wants to remain in currently not collectible, it's probably going to be a case of them being very consistent with their income. However, it's always a good thing, I suppose, when they make more money next year versus staying comparable. So I mentioned the expected income increase, and some of the examples, again, located in IRM 5.16.1.6.4. They would include currently out of work, but they have a job lined up, and they expect to start 6 months from today, or whenever the case may be. The IRS can set the currently not collectible to mimic that time frame that they are out of work, but expect to have a new employer. Again, incarceration, that comes back up. Obviously, those who are incarcerated do not earn a living, generally speaking, and it's pretty straightforward when they are expected to be released from their incarceration. And so a lot of times the IRS has the ability to set forth the currently not collectible to coincide with that release date. One of the things to remember is when a person is released from incarceration, one of the requirements generally for their probation is they are required to find employment. And at that point, they have a source of income, and therefore the IRS would then consider them having the ability to pay their past due taxes. And finally, if we have the ability to pay off some debt. In many cases, when I was at the IRS, I saw a lot of car payments that were about to fall off, or they only had maybe a year left on their car payment that would add maybe $200 to $500 a month in disposable income. And that's another situation where you can prove and you can tell when the payments will end, and that would be the appropriate time to have the person removed from currently not collectible because they will have that disposable income. Oh, and one last thing is the potential for windfall. And I mentioned if you're expecting an inheritance or there is some funds that are owed to the taxpayer that they can guarantee are coming in. Windfall does not include the anticipation of winning the lottery because it's only what you can prove, not what you can hope for. So keep that in mind. Okay, so that basically covers all of the hardship section. And again, keep in mind that probably the majority, if not 90%, as I mentioned earlier, of currently not collectible cases fall under the hardship category. But there are a few other situations that currently not collectible can apply. And the first one that we have is defunct entities. And that's defined as under IRM 5.16.1.2.6.1. And basically what it means is you have a business, they are no longer operating. They don't have any assets, they don't have any receivables, they don't have anything, and they're not doing anything. They're just sitting there. Probably the officers or the members or wherever the case may be have moved on and have gotten jobs elsewhere, or they have income from other sources, and it's just not doing anything. That would be the perfect example of an entity that would qualify as a defunct entity. And let me give you an example again. So I had a chance to speak to a gentleman from Florida when I spoke at a conference, and he came up to me after I gave a presentation on offers and compromises, and he gave this perfect example of what we're talking about. He had a couple of clients that had an LLC that had stopped doing anything as of 2011. However, they had a hard time distinguishing themselves from the LLC because entrepreneurs believe that they are the business and the business is they. So they felt obligated to pay the money that the LLC had incurred in taxes, when in reality, it was the type that it should not have been paid by those folks. It was the responsibility of the entity because it's a standalone entity with its own EIN. There was a line of demarcation between the individuals and the business. So after getting the details, I simply told the gentleman who asked me about this was they need to stop paying and submit the request to have that LLC be considered a defunct entity or out of business as a defunct entity and be placed in currently not collectible. So that's another example right there. So again, going back to, well, we have to prove it, correct? The IRS expects you to prove what you're claiming. So how do we shut it down and prove to the IRS that this truly is a defunct entity? Well, first and foremost, most organizations, you are required to file with the state of your choice to establish the corporation or whatever the filing is. So the first thing that you would want to do is file the correct paperwork to shut it down with the state. Next up, you would want to file a final return with the IRS, and whether it's an 1120 for a corporation or what have you, there's always a box on the return that allows you to mark as final or final return. That's another check as far as proving that this entity is no longer operating. And then next up, the IRS is going to want a collection information statement, in this case a 433B for business. And what they're going to want to know is, at the time that you kind of stopped doing anything, did it have any assets? Did the business have receivables? Did they have equipment? Did it have real property? If it did, what happened to it? Was it sold? Was it transferred? Was it liquidated? And if it was moved to somebody else, who was that person? Was it an arm's length transaction? Was there money or consideration given for that asset? And it's not just $10 in love and affection. It actually has to be real money in exchange for the asset.